go. You're going to want to hear this. The marijuana party status on the line as Minnesota Supreme Court weighs a challenge. The Minnesota Supreme Court is likely to decide within a month in a legal marijuana now party will retain elevated status after arguments Tuesday that focused on its unique leadership structure and the state's laws governing party control. The DFL party sued to strip major party certification, arguing that legal marijuana now failed to meet the operational threshold for retaining the major seal it first attained in 2018. The case is being expedited because candidate filings begin in a little more than a month. The outcome matters because more parties get automatic ballot access and campaign subsidies and the ability to have poll challengers during elections. Candidates in minor parties need to gather petitions to get on ballots, and currently the three major parties are the Minnesota DFL, the Republican Party of Minnesota, and the Legal Marijuana Now Party. State law requires major parties to hold regular conventions and meet other leadership standards, and according to filings in the case, Legal Marijuana Now prides itself on having consensus-driven doobie rules, they call them in parentheses, and vests much power in the head council, or THC for short. Instead of deferring to decisions of conventional delegates, a court-appointed referee previously found that the legal standards weren't met by this agreement. Still, the Supreme Court's oral arguments made clear that justices were uncomfortable setting the bar between minor and major parties in the state in a first-of-its-kind case. Chief Justice Natalie Hudson pressed a DFL attorney why the state should be involved this deeply in party affairs, and in quotes they said, they may not be orderly in terms of what the DFL would like to see or what anybody else would like to see, but Hudson said early in the 70-minute hearing, but do they have to be, he says. Justice Paul Thiessen posed a similar stirring of questions to lawyers throughout the arguments, although Thiessen said it could not help state officials get a clearer idea of who to listen to. When it comes to party affairs, he added, why does the state have to dictate which of those entities have to be listened to? David Toll, the attorney for the DFL, responded, just as there are tiered leadership requirements, there are tiered benefits that come with that status. Zoll said later in the hearing that major parties are rightfully held to a higher standard, and in quotes, they can organize themselves however they want to, he said, but if they want the benefits that come with major party status, they have to satisfy the statutory requirements. During his turn at lectern, Legal Marijuana Now attorney Eric Cardial disputed the arrangement fell short. In quotes, he says, my client read the statutes and Constitution, thought they did what they had to do, and would do more if they had to do it, he said, adding that the organizational decision was about efficiency, not defiance. The two marijuana-related parties won major status back in 2018 after at least one of their candidates won at least 5% of the vote in a statewide race, and grassroots legalized cannabis fell down a rung after failing to meet that threshold in following elections. Legal Marijuana Now has held on, although it hasn't had much success as of late. But candidates for the party have vexed Democrats in some close contests since 2020 because they've managed more than the margin of victory for Republicans over Democrats. DFL leaders also say the ballot line has been used for political mischief. In the campaign finance report filed on Tuesday, the Legal Marijuana Now party revealed its bank balance at this stage in the election year is $830. Major party candidates can qualify for state campaign subsidies amassed through an income tax checkoff, and two justices have recused themselves in the case. Carl Procanci and Margaret Church. The reasons they aren't required to specify, meaning the ultimate call will come down to the remaining 5. Jan Woodruff, an attorney for the Secretary of State's office, asked justices for a swift decision, and in quotes, if decided by May 15th, it will provide all parties to the election, candidates and the secretary and the other election administrators throughout the state enough time to proceed with knowledge of what their requirements are, Woodruff said. The 2-week candidate filing period for most state and federal offices on Minnesota's ballot opens on May 21st, although parties have until late August to submit their nominees in the presidential race. And in quotes, we'll try to be as prompt as possible, Chief Justice Hudson said in his adjourning of the hearing. Well. Can't wait to hear. And Rico, I hope you are still here to hear what you have to say about this. Oh, he's gone. He is gone.
Well, I think that it involves 2 First Amendment rights. The Supreme Court already said that money you pay for political parties is freedom of speech. Okay? And there's also freedom of association here. These are fundamental federal rights. And I'd like to see what tests they're going to apply to these requirements, because it's got to be more than the rational basis. I'm not sure it's a strict scrutiny standard, but an intermediate scrutiny. It's got to be, carefully crafted to meet an important governmental interest before you interfere in someone's right to be some political party. So I'm curious to see how they address that issue. That's kind of geeky lawyer shit.
I'm with it.
I think they should dissolve the party just on the basis of those 2 awful puns, the doobie rules and the health
THC,
council or whatever the fuck it was called.
THC, the head council.
The head council, yeah. Just on those 2 alone, dissolve the party. I'm against it. Abolish it.
Look at this. I can't believe you said that. That's so funny.